I'm going to take roll call. Alex Lawrence.
Here, we're going to call the meeting to order, and Mr. Angelos, will you take roll, please?
Yes, thank you. Alex Lawrence.
Here.
Dr. Bolton.
Here.
Robert Brody.
Here.
Dr. Cow.
Here.
Alex Chan.
Present.
James Efting. Kareem Gungora. Dolores Heisinger.
Sky Elliott.
Judge Herman.
Mhm.
Michael Asari.
Mhm.
Larry Kaplan.
Here.
Mhm.
Paul Kramer.
Mhm.
Esther Lynn.
Mhm.
Bethany Peak.
Mhm.
Vince Reyes.
Here.
Mhm.
Judge Torrealba. David Torres.
Here.
Don Wilcoxon.
Here.
Okay, thank you.
Okay, thank you. As noted on the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. The committee has received and read all the written public comments. We thank you for that. The committee coordinator will attempt to call members of the public in order that they appear.
Okay,
Now,
let me.
To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers, and to allow the committee the time needed to deliberate on the important topics that it will be discussing today. We'll be limiting public comments to 2 minutes per person. Now, with regards to logistics for raising hands, for those of you who are participating via Zoom video, you should have a function for virtually raising your hand. It's a hand icon and should appear at the bottom center of your screen. If you wish to make a public comment, please click on that. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. The coordinator will call members of the public in the order that they identify raised hands and will enable the microphones of the speakers. Now, as discussed at our last CBE meeting, we'll be taking public comments from law schools in a different format at today's meeting. Law school deans that would like to make public comment during their corresponding agenda item will be allowed to do so once their agenda has been presented by the subcommittee chair and staff. We also have various locations located on the agenda, and we'll open for public comment at each of those locations once we hear public comment from public members attending via Zoom. To start, Ms. Nunez, do we have any public comments from public members attending via Zoom?
No, we do not.
Okay, are there any public members?
Sorry, Alex, we have one person who just re-raised his hand, Mr. Pete Bennett. When you're ready, you can start your public comment.
Can we hear me now? There we go.
Yes.
My name is Pete Bennett. I'm a resident of Contra Costa County since 1978. I have gone into courtrooms and lost millions due to fraud, murder, arson, extortion, and racketeering. I have more than 10 federal indictments near me of police officers. I was instrumental in getting District Attorney Mark Peterson arrested. I wish he spent a little more time in jail in 15 minutes. And I have complaints across the board. My blog, you'll see Dead Witness. When you go there, I'd like you to take a look at Attorney J. Ryan Moss and look at her cases. Because the guy that's in jail was more or less a counterpart when I worked in mortgage-backed securities. He worked at World Savings. Bad thing. My attorney, Mark Angelucci, shot dead. Now for the college that took over JFK University. I used to own a house right next to that property. A man was burned alive in the trunk of a car. Then another guy was shot dead. Then the farmer disappeared. He's probably buried under the, whatchamacallit, the Boy Scout Center. I've been pushing for justice for these people for years. I can't get an attorney. They need to wear, what do you call it? A bulletproof vest. They need to go with a courtroom knowing that they could be shot at. This is a tragedy that's just dragged on for years.
Mr. Bennett, your time's up. We're at 2 minutes, so thank you.
Are there any additional comments, Ms. Nunez, before we move on to at the physical locations?
We do not have any more hands raised in Zoom.
Okay, thank you. Are there any public members at any of the physical locations that wish to make a comment? Does not.
Yeah, it looks like we do not have any members of the public in any of the physical locations.
Okay, thank you. We're going to move on to the open session. The next item is, sorry, looking at my notes here, approval of the March 18th, 2022 Committee of Bar Examiners open session meeting minutes. Is there a motion from the group?
I'll make the motion. This is Kareem.
I second the motion and let's go. I am now online.
Thank you. Can we have a vote?
Dr. Bolton? Robert Brody?
Yes.
Dr. Kao?
Yes.
Alex Chan?
Yes.
Kareem Gungor?
Yes.
Dolores Heisinger? Michael Iseri?
Yes.
Larry Kaplan?
Yes.
Paul Kramer?
Yes.
Vince Reyes? David Torres?
Yes.
Don Wilcoxon?
Abstain.
Thank you.
Thank you. So now we're going to move on to the next item on the list, and that is the report from the director. And I would like to just remind everyone to please mute your phone or device if possible. Ms. Nunez?
Yes, thank you. So today I'm going to present to you starting with the key indicators and PowerPoint's coming up. So this is a standing agenda item where I usually highlight applications that have had a 15% more change or more when compared to the last year. And as you can see here, it's clear that 2021 was an anomaly for us. As you can see here, in terms of the number of applicants placed on the motion, what we're looking at right here are the numbers from January through March 2022. We have a 90% difference where we're at this March compared to last March in terms of the number of applicants placed on the motion. And that's really a ripple effect from the 2021, which is a very different year for us. It's a ripple effect on the late results from the previous year. As for both attorney registrations and law student registrations, this year there's a 19% decline in attorney registrations and a 21% decline in the number of law student registrations. And this may be reflected by the fact that last year we had an online exam for both February and for July, which allowed more people from outside of California to apply potentially. This could be explaining that differential. As for, and that explains also part of the general bar exam applications and attorney exam applications. Again, general bar exam applications are people who are sitting for the 2-day exam. Attorney examination applications are applications of those attorneys who have demonstrated through certificate of good standing that they are eligible to sit for the 1-day exam. And here we can see a very big differential, 34% less applications compared to last year and 68% for attorney exam applications compared to last year. In the next item that has a 15% or more difference compared to previous years are the moral character applications as well as the extensions. We have 15% less this year compared to last year, and also for the extensions, 102% difference. And this is correlated with the fact that we were also going through the provisional licensing program. Last year, applicants were actively meeting these obligations in order to qualify for the PLL, which could explain part of this differential. And the last item is the multi-jurisdictional practice applications. Again, this includes the provisionally, those licensed, I'm sorry, I don't mean to call a provisional license, but those licensed either as registered in-house counsel, registered military spouse attorneys, registered legal aid attorneys that qualify under this. There's a 44% increase this year compared to last year in March in those aspects. Any questions related to the key indicators before we go on to our next updates? Okay. All right, the next item is simply a reminder. Our next CBE meeting is scheduled to be held June 17th through the 18th, 2022. Right now, it's going to be scheduled as a teleconference, much the same way that today's meeting has been scheduled. We will adhere to Bagley-Keene as we have for this meeting. And so we have more information and planning to do in terms of in preparation for that meeting.
Good morning, everyone. The June 2022 first year law students exam will be administered primarily remotely on June 28th. Those applicants with accommodations or extenuating circumstances will be provided with an in-person location to take the exam if needed. As of today, there are 238 submitted applications for the June exam. Until April 29th, there's a $25 late fee for application, and then that goes up on to $200 on April 30th if anyone listening is planning on applying. Looking forward to the July 2022 bar exam on July 26th and 27th. Last week, we posted FAQs related to the exam. If there are any applicants or law schools listening today, please read through the FAQs and send in a general request if you have questions on what is posted. Until April 29th, applicants can apply for the upcoming bar exam with a $50 late fee. On April 30th, that goes up to $250. As of this morning, we have 6,049 submitted applicants for the July exam. We have also recently updated our test center page. We added Anaheim Convention Center to the Southern California testing locations, so there will be plenty of seats statewide. The results of the February bar exam will be released after 6 p.m. on Friday, May 6th, and there will also be the time when the July bar exam application will open for immediate repeaters. Any questions?
Quick question, Audrey, it's Kareem.
Hi, Kareem.
Good morning. This is in person?
Yes, yes, that's a good question. Sorry, I forgot to mention that. The June first year exam will be remote. The July bar exam will be in person.
Okay, thank you so much. I appreciate that.
Thank you for the clarification.
All right. So this next update is related to the provisionally licensed lawyers program. As you recall, sorry, my screen keeps switching. As you recall, PLPs or provisionally licensed lawyers can qualify under two separate categories. The original cohort included people who had a graduation date between December 2019 and December 2020. Of those, we had a grand total of 915. These are statistics as of April 13th that have participated in that program. Currently, 249 are active, and for the program expansion. So the program was expanded to include anybody who had scored a 1390, which is a new cut score for any bar exam between July 2015 and February 2020. The ability to participate in this program. And so on top of participating as a provisionally licensed attorney under the supervision of a California licensed attorney, they would also qualify to become licensed without having to pass another bar exam. We had a total of 671 applicants participate in this program. To date, 424 have been admitted to the bar. And we currently have 234 that are still actively participating in the program. As a reminder, this program sunsets on June 1st, 2022. So by the time our next meeting happens, the program will have ended. We will have statistics on what the participation rate looked like. Also, we have informed those applicants, reminded them about the ending of this program. And so they have been informed. Also, prior to the February bar exam, we also had reminded the applicants that qualified under the based on graduation date we encouraged them to sign up for the February bar exam, as that would be passing that exam would allow continuity in their current employment if they choose to continue. If you check out the next slides, please. So these are the demographics of those that have been admitted to the bar. So this includes in the expanded pathway, the 424. And as you can see in these categories, in terms of race and ethnicity, the majority of these applicants are white, followed by Asian. Next slide, please. In terms of the law school types, here the majority, as you can see, come from California ABA law schools, followed by California accredited law schools. Next slide, please. And in terms of gender, the majority of those admitted via the pathway or that have become licensed are female. So with that, I open it up. Does anybody have any questions about the provisionally licensed program? Okay.
No questions. Amy, just a quick comment, if I may, Mr. Chair. Okay, thank you. Amy, I just wanted to say thank you for providing this. I know I've asked for this in the past, and so I just want to thank you and the team for keeping an eye on some of the demographic information. I think it shows some progress. I think we definitely have some way to go. I know the state bar is doing a lot of work in justice and equity and diversity and inclusion, and so just looking forward to see what else we could do to improve some of those equity gaps.
Thank you, Kareem. All right, I turn this now back to you, Chair.
Great, thank you, Ms. Nunez. And there's no other reports on recent developments, right? Just want to confirm before we move on.
I just do want to highlight one thing. So we've been receiving questions about the status of our admission ceremonies. And so we will not be hosting admission ceremonies. As many of you know, we have moved on to the ability to provide virtual oath cards. And this was based on the need during COVID when we weren't able to gather together. So the progress that we've made with creating these electronic oath packets have really facilitated an ease for law schools to provide their own swearing in ceremonies and for applicants around the globe to be able to get to a swearing in more easily, rather than waiting for the hard copy card altogether. So even before COVID, we were also experiencing a reduction in the number of people participating in the swearing in ceremonies. So between our move for digital transformation, which has reduced the request for the number of for ceremonies, we've decided that we're no longer going to be administering the ceremonies themselves. So we've already alerted the schools at meetings that took place on Wednesday We're going to add this language to our website, but we have results that are coming up on May 6th, and that is part of the information that we will be sharing. So that's the latest update.
Thank you, Ms. Nunez. So we're going to move on to the next item on our agenda. It is the Examinations Subcommittee. I'm going to turn it over to the chair, Dr. Cal.
Thank you so much, Alex. I think we're going to go ahead and get started with the examinations. If Esther and Alex and Paul could give us updates on discussion and recommendations regarding recent and upcoming recommendations of the Blue Ribbon Commission on the future of the bar exam and on NCBE's NextGen examination. If Esther, Alex, or Paul could go ahead and discuss that.
Sure, I can give an update on what happened at the last meeting. We had a meeting on April 6th, which focused exclusively on the exam pathway. And at that meeting, we discussed the topics that should be tested on the future California bar exam, and also the relative weights that should be assigned to those topics. For the current bar exam, just to refresh our recollection, 13 different topics are being tested. The recommendation, which was voted on, reduced that number down to 8. And those 8 topics are civil procedure, con law, contracts, crim law and crim pro, evidence, real property, torts, and also a new topic, and we call that admin law and procedure. In other words, business associations, community property, professional responsibility, remedies, trust, and wills are going to be eliminated from the future bar exam. And that is if the California Supreme Court chooses this pathway over the non-exam counterpart. At the last meeting, I did voice my concern to the full commission about making a hasty decision and voting on this recommendation without any time for the CBE to digest that information, including excluding certain topics that appear to be critical based on CAPA's own statistics. I was, however, outvoted, and the commission voted in favor of this recommendation. At the next meeting, the commission will turn its focus to the draft framework for the non-exam pathway. I know Audrey has the draft and she circulated it to me and Esther. But under the current draft, the proposal is to start the non-exam pathway in law schools. This includes a combination of doctrinal and experiential learning, and law schools would be basically tasked to implement some of these options, including clinics and practica and simulations. There would also be a work product review, either by an independent regulator or by some other means to be determined at regular intervals during that pathway. And then once an applicant graduates, and this is the sort of the law school path, applicants would be subject to something very similar to the current provisional licensure, where they would be required to be under the supervision of licensed attorneys. The time range is still up in flux. It could be anywhere between 5 to 8 months. There could also be some form of a centralized or decentralized administration of the supervised components. That could include matching supervisors to applicants, as well as instituting certain requirements for supervision. There's also a third element to this, which is assessment, where applicants would be required to complete a prep course involving online modules or some kind of in-person simulations or mini exams. Or as an alternative, they would be required to take the California performance exam. And so that's sort of the overarching theme for the non-exam pathway that the commission will discuss at the next meeting. And so that basically sums up what happened at the last meeting and what will happen at the next meeting. I don't know if Paul has anything to add. I know Esther is not here today, so I will open up the floor for questions.
Well, first a comment on, I just don't like the idea of the alternate pathway the way you've described it. I'm resisting in another, at the CS bars level, a sort of trend to make law schools even more just focused on passing the bar exam at the expense of a breadth of legal education over, more of the topics that they might find themselves dealing with as lawyers. So I'm also not terribly pleased to hear about the reduction in subjects. One specific question, it's been my understanding that the Supreme Court has wanted us to focus on professional responsibility in the bar exam, and that's why it is a more frequently occurring question than others. I wonder if the commission was aware of that. I would think unless the Supreme Court has changed their position, they would be really reluctant to remove professional responsibility from the exam. And then I'll let the others ask their questions. And then after that discussion is over, I'll come back and talk about the next generation exam.
Can I just answer Paul's question in terms of the professional responsibility aspect? So what the BRC did at the last meeting was basically agree to the recommendations that were originally set in CAPA. And so in the reduction to the 8 topic areas stems from the CAPA recommendation. And part of that discussion did involve how professional responsibility is currently handled and what the implications of the recommendations would be. So yes, just to answer that question, the Supreme Court is aware.
Yeah, and I would also add that I believe the CAPA group, its recommendation, I think their view is that professional responsibility is tested through NPRE, and so they don't want to make the materials duplicative, but also professional responsibility is a mandated course in law school, and so that sort of adds another layer of protection to ensure applicants are aware of and have sufficient knowledge and professional responsibility. So with those 2 layers, I think the CAPA study group recommended that we could do away with professional responsibility in the exam.
Okay, I don't feel bound, and I remain in disagreement.
See, Mr. Brody's hand is up.
Yes. Hi. I just wanted to piggyback a little bit on what Alex said. For people that might have forgotten or are newer members, the State Bar established CAPA back in 2018, largely with the idea about what content should be on the bar exam. Not how we test, but what will we test on the bar exam. And that was largely brought about by a perception that we had too many topics and that the test was becoming one of memorization. So there were 13 topics, and there are 13 topics tested on the bar exam. So I want to make sure that everyone understands that what happened next was a consulting firm was retained, and there was a fairly large, many of you will probably remember, surveying that was done of members of the bar. We had over 30,000 responses to a survey that talked about what you do and how you do it and your priorities. So it was fairly comprehensive with a great success rate. From new lawyers was the focus, new lawyers being between new admittees and 3 years. And we looked at the number of topics that to explore went up to 18 from the 13 that were tested. And then over the course of probably 18 months, CAPA, which was lawyers from large and small firms, law school deans, sitting judges, and your CBE representative, me, in addition to Donna and Amy and Lisa, participating in those meetings to look at which were the topics that were required for the entry-level practice of law and the ethical representation of clients. Now, everyone around the table, the CAPA was about 25 people, had some lobbying to do for their own areas of practice. And Alex, there was some interest in including business and business litigation and business practices in the final count when it was reduced from the 13 on the bar to 8, in addition to identifying some soft skills. So I just don't want anyone at the CBE today to think that this was a hurried or rash. It took over a year of a lot of people looking at the numbers, and at the end of the day, we identified a set of core legal topics that are foundational to the practice of law, which are reflected largely in fundamental legal skills such as issue spotting and legal analysis. That is the description of how we winnowed it down to the core legal topics. So it was with a great deal of thought in choosing those. And I guess, I just didn't want anyone to think that there was anything cavalier about trying to make the bar subjects more manageable and how we arrived at the subjects that we were going to choose. There are probably a dozen charts that rank all of the subject matters from civil procedure down to securities in terms of areas practiced, areas used. This is over 10,000 new lawyers between 0 and 3 years. So I guess I want everyone to know that what was presented to Blue Ribbon was as a result of a fair amount of study by the bar. Okay, thank you. Alex, one of the deans was from Alex Chan University, otherwise known as UC Davis. So there we have it.
Appreciate that. Yeah, I absolutely agree with you, Brody, in terms of what you just said. It took a lot of effort and also time to come up with those 8 topics. I think the only issue I had that I expressed to the commission was that there was also some subjectivity involved, especially where the CAPA group gathered statistics and some of the statistics just aren't consistent with the choice that was made. And one of the topics that was ultimately eliminated actually had a very high score based on the survey and also from the composite score that was calculated. And that topic was business association in California, to eliminate business association where I would say more than 50% of transactions have to do with commercial businesses. To eliminate that topic wasn't really something that jives with me, but I expressed my feeling to the commission. It is what it is. There was some component of subjectivity that wasn't entirely based on the scores that were calculated.
Okay, Philadelphia.
Any other questions from anyone?
Let's see, Mr. Herskowitz's hand is up.
Yeah, so I just wanted to provide just a small bit of clarification. When Alex was describing the framework that was presented, he indicated one particular area, so number of supervised hours that was in flux. I just want to be clear, the framework is a discussion document. The framework was put together based on what staff had gleaned from the prior conversations of the Blue Ribbon Commission, as well as just sort of putting something on paper to get the discussion going. There are so many different components to this non-exam pathway that we thought it was really important for the commission to have something very specific to react to. And that's what this framework is. And we did wanted, Audrey did the heavy lifting on the framework and really pushed to make sure to be able to get it to Alex before this meeting. You all are getting a preview of it, frankly, before the members of the commission are, because we did want to make sure that Alex had the opportunity to talk to you a little bit about it, so he could get your feedback and incorporate that in the opinions that he expresses at the Blue Ribbon Commission meeting that's coming up in a couple of weeks.
And I think I really appreciate that you made an effort to do that, Donna, because we've been talking mostly, even myself, about a decision that's been made and that we have no real immediate direct input about. But we should be giving Alex a sense of what we would like him to convey to the commission regarding this other pathway. And again, something where it's largely based on the certification of supervising attorneys. There's no test involved, and especially if the amount of time spent in the supervised practice is as small as it is for the PLL program, or rather the pathway. I think it was 300 hours. That, to me, that's just ridiculously short period of time, and doesn't allow the skills and the abilities of someone to be properly assessed. So those would be my concerns. I really don't favor that pathway in general, but especially if it's so watered down as I believe the PLL program was. And I'm speaking as a member of the group that developed that program. I would be strongly disfavoring it.
Maybe Audrey can give you a little bit more pieces of the framework, just so we want to make sure that that you're reacting to the same framework, the same information that the BRC, the Blue Ribbon Commission, will be seeing. Audrey, maybe if you walk through a little bit more of it.
Yeah, and I can share it. And again, it's draft, and I shared it with Alex and Esther, so they could have it for today's meeting. But all of it is up for discussion as explained. So talking, and Alex did a great job kind of reading through these components and possibilities about how non-exam pathway might work with the law school implementation, including, an increase in experiential education to be determined. Post-law school requirement, again, a lot of this is obviously up for discussion and to be determined about will there be supervised practice, how much time in supervised practice after law school, how will that be administered, the requirements for supervision, and then this third component of how those in the non-exam pathway will be assessed. We heard in the subcommittee for the non-exam pathway from a lot of the jurisdictions in Canada that do what they call articling, which is their version of supervised practice. And along with articling, they do a prep course where they also have several months of in-person and online lawyering skills, including mini exams. So there's a lot of robust moving parts in the framework to discuss and to see where the Blue Ribbon Commission lands.
But one problem I see with this is that it won't provide an immediate fix that people are probably jonesing for, because you're going to have to go through 3 years of law school. It's going to take a while to develop that curriculum, 3 or 4 years. And so the first graduates or successful lawyers that would emerge from such a program probably wouldn't do so for 5 or 6 years. And in this, when it yesterday society, I don't see how that's going to work out. And my fear is that in order to meet the needs of the inpatient, that it'll be watered down in ways that will affect its quality.
Michael?
Yes, I have two quick comments, probably three, but I'm more concerned with, first off, Alex and Asa, excellent job. Thank you for representing our interests. My first comment is probably to do with just the alternate program or alternate routes, whatever of the devising and everything. I just see this as potential room for abuse because as always, when you have gatekeepers at different avenues, the gatekeepers can be corrupt. Gatekeepers being attorneys who supervise other individuals in whatever capacity. And I just don't know how you can implement such a program. I know we had it before. That's amazing. However, when you make it more broader, it's always an iffy thing because it's more, I don't know, it's based on my own law experience or legal experience about just how different law firms will definitely abuse new attorneys. I always joke around, but this is more or less like puppy mill forms of just essentially just hiring these low cost, not even attorneys because of an alternate program at that point, doing work or stuff, and it just never turns out good. This is for all avenues. It's not only in the Riverside San Bernardino area, it's also, you know, in major cities, Los Angeles and all that stuff. I being SoCal, I just reference those. Second comment is more about this could negatively impact, even though it's supposed to help, it could also just negatively impact minority backgrounds, specifically with individuals with disabilities. Again, it's just, if you have gatekeepers at different avenues, you're now putting the trust in gatekeepers. That's for any type of technology or policies or anything like that. I can go on and on about gatekeepers and technology, but that's another thing. But gatekeepers are more, I just, like I say, there's room for corruption. And even though the best intent is for broadening legal opportunities, there's, without proper regulations and everything, there's room for not only corruption, but just abuse. And then this is on the previous note about the removing on the professional responsibility topic. I understand the arguments made 15 minutes ago or so about why it's heavily tested upon and everything. But I can contest to, within my past year or 2 years of legal practice during COVID, I have met the most unethical attorneys and racist attorneys in my professional career during COVID. So I highly suggest that we need to not only have professional responsibility still in essay format or something like that, but also I think we should actually include DEI initiatives, because I won't go into it, but I can't believe I met some of the most racist attorneys in the past 2 years.
Thank you, Mr. Sari. I think I see Mr. Gongara's hand.
Yes, thank you, Mr. Chair, and thank you all for your comments. And I do want to thank Alex and Esther for their work, as well as staff on proposing what I believe is a step in the right direction. I am actually in favor of a more broadened path, and I say that with being mindful to the statistics that we saw this morning with the PLL program. As you see, there's not a lot of growth being done within relation to diversity and inclusion. we are seeing still Black and Brown communities being at a disadvantage when it comes to access to the bar. And so I think there's a way we could do this. I think we could do this very constructively and in a way that we're mindful of things such as gatekeepers, and then also not so much lowering the bar, but also providing access and equity in that regard. So I actually support that. I think I really appreciate that staff actually put that on the table because I know it's not something that's widely popular, and I know it will be scrutinized. I know we'll go down a path where we'll discuss the intricacies, and that's okay. Because I think sometimes with policy, we want to be perfect, and sometimes we just have to look at what we've done, look at where we are, and then also have a vision of where we want to go. And so I just want to say thank you, Alex, for being our voice and kind of helping us pave that way.
Are there any other comments?
Just out of curiosity, is there anyone not in favor of the non-exam pathway?
Aye.
Maybe me, it depends on whether or not we have proper regulations or proper vetting.
How about this? Let's put it this way. Anyone in favor of this non-exam pathway? And if you can just give me your thought on it, and I can take it back to the full commission. Noted.
I think a lot of why you might not hear people speaking on it is because it's kind of complicated and it's early in the game. So I think maybe as it's more fleshed out, we might be able to discuss particulars. But I think for the most part, the only thing we could reference is the PLL program. And as we see, it has been a success. But based on the percentages, you'll see that it's still incremental in meeting our equity and diversity goals. And so that's something that I guess for me, Alex, I would be mindful of.
Understood.
I'll just add in response to Kareem's point, the provisional licensure program was obviously put together very quickly to deal with an emerging situation. So, you know, one of the things that we've talked about is exploring who could participate in pairing interested students with supervisors. Is it something through the law school, through CLA, California Lawyers Association, working with regional affinity bars? There was a lot of the, in the provisional licensure program, the applicants were largely left to their own devices to identify supervisors. And so one of the things that the Blue Ribbon Commission is very alert to, and we have 2 members of the Council on Access and Fairness on our commission for this very reason, but they're very alert to ensuring that there are equal opportunities to everybody to participate in this program. And so figuring out a way that we can have that anybody who's eligible for the program can have access to a supervisor. We're looking at doing something that we didn't do with supervisors for the provisional licensure program. We think that there absolutely needs to be training. There needs to be for what it means to be a supervisor, what you're expected to do. Potentially there's a checklist of things that as a supervisor you would be expected to have the applicant that you're supervising work on. A variety of things like that. So there would necessarily the commission has talked about sort of the strong need to really not just emulate the provisional licensure program, but to really beef it up in so many different ways.
Well said, Donna. I don't expect the BRC to vote on this pathway. Instead, I think a lot of the time will be focused on revising or amending the contour of this framework. If so, at the next CBE meeting in June, I will take it back to the committee for additional guidance and comments to this framework.
Are there any other thoughts at all? Well, I really like to appreciate Alex for such a very thorough discussion, and same for Paul and everyone's very thoughtful comments. concerning this this very important topic. So we appreciate all your work, Alex, Esther, and Paul on this.
Before you go on,
Yes.
I was waiting to do the next generation bar exam report.
My apologies, Paul.
So I think Larry Kaplan and I were the two members of this committee, along with a lot of staff who attended that workshop that the National Conference of Bar Examiners gave a few weeks ago, trying to brief the people like us in the various states on the status of the next generation bar exam that they are working on. And the takeaways I took, and Larry, if you want to add on after this, feel free to go ahead, was that they were finding very difficult problems with the idea of open book testing and how you would do it. For instance, there's an argument to be made that people of means will probably have better books to open, and trying to equalize, what the let's say they decided to pick a set of books that everyone would use. Just trying to police that, but also decide what should be in the mix and what isn't. That would be difficult and time consuming. So they seem to be really sour on the idea of open book tests, which I gather isn't taking much traction with the our commission either. But and then a big potential issue for us is going to be that they're not going to after the next gen exam is up and going, there might be a limited period where they'll still have the multi-state exam available, but eventually the multi-state bar exam is going to go away. And that's a tool we've been using to scale our own exams. And so I'm not sure how we would, what we're going to do to replace that, but that's certainly an important consideration. We can't count on that tool being there, just, and then say offering part written and using the NCBE for the multiple choice part of our exam. It may no longer be there for us. But they are targeting making their exam, which would be a combination of performance testing. That's all still a little bit vague, written essays, maybe some multiple choice. But they're targeting to make that last less than 2 days. So one option for us might be to use that exam and then supplement it with a California only exam component of our own. I know that's not the way that our commission is going either, but that's out there as a possibility. And then they're making their lives potentially even more complicated by proposing to give the exam over a period of 3 weeks. So, and then because you can't give the same test, the same questions every week, because the later people, probably nobody would take the first week because they would want to hear from the few people who took the first week's test to know what the questions are. So they would then have to create basically 3 different exams to give in that 3-week window. And they would have to scale those. It just sounds like a very complicated endeavor, but that is one possibility. And they also think about giving the exam in or using private proctoring facilities as testing centers, which probably doesn't scale up for us, because we have so many more takers every exam administration than a smaller state would. But it was fascinating to listen to, and those are the takeaways I had. Did you have anything else, Larry? Okay, I guess not. That's my report. Thanks.
Thank you so much, Paul and Larry, for that presentation. Just moving on, the agenda would be approval of the reports on the 2021-2022 examination goals, agenda item 0200.
This is Robbie. I'll make a motion to approve.
Thank you, Robbie. Is there anyone that can second that motion?
This is Michael Iseri, I second.
Thank you, Michael. Can we do a roll call?
Dr. Bolton, Yes. Dr. Kao,
Yes.
Alex Chan,
Yes.
Kareem Gangora,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Vince Reyes,
Yes.
Judge Torrealba,
Yes.
David Torres,
Yeah, so
Don Wilcoxon.
Yes.
Thank you.
This is Michael Seri. It's a yes. I think you've skipped me.
Oh, yes, I'm sorry. I put you down as seconding it. Yes, thank you.
Oh, yes, yeah.
Sorry.
Dr. Cal, you're finished.
Yes, I am finished. Sorry, I had to figure out my mute. Thank you so much, Alex.
No worries. Thank you, everyone, on that item. And we're going to move on to operations and management, and I'll turn it over to the chair, Mr. Epting.
This is Michael Seri. I'm taking over for Mr. Apting in his absence. Let's see. The first item on operations and management for open is the discussion of revisions to the State Bar Rule 4.17. I believe that we have a presentation or discussion on that.
Yes, so this is Donna Hershkowitz. I will open the discussion and then turn it over to Tammy Campbell and Amy Nunez. So I just wanted to start by reminding everybody what Rule 4.17 is. Rule 4.17 provides that no later than 5 years from the last day of administration of the California bar exam, that an applicant, so if an applicant takes the bar exam and they pass, they have 5 years to meet all the requirements for admission and to get certified to the Supreme Court and to get sworn in. So as the committee members know, there are individuals who pass the bar exam, have met all of the other requirements, get put on the motion, and for a variety of reasons don't get sworn in over the course of 5 years. It's a small number. There are other individuals who pass the bar exam and then during the period of the 5 years, complete all of the, or try to complete all of the requirements, such as getting, submitting their moral character application and getting a positive moral character determination. In some instances, individuals are not able to meet the 5 years and are and request an extension of time, right? Essentially, the way we talk about it is that your bar exam score expires after 5 years. So they request an extension of time, which is a process that goes through staff. And then if denied through staff, the applicants have the opportunity to appeal to the committee, and then the committee hears those requests for an extension of time. So this rule recently was brought to our attention regarding a specific applicant, which is the way a lot of this stuff comes to us. There was an applicant who had passed the bar examination, and because their job didn't require California licensure, they thought they might not stay in California long term. Didn't sort of take the steps to file a moral character application and ultimately get sworn in. Once they had decided that they were going to stay in California and it was worth it to take advantage of having passed the bar exam, they decided to pursue licensure, completed a moral character application. Ultimately, the 5-year clock ran out. And in this particular case, it happened to have run out by an incredibly small period of time. The applicant requested and was denied an application of the extension of that 5-year clock. And although I did review how the applicant's case was handled and concluded that, in my opinion, it was handled appropriately in terms of how we processed the documents that were submitted by the applicant, the timing of considering the moral character application, the processing of the request for 5 years, and the appeal to the Committee of Bar Examiners. The fact of taking a look at this really gave us the opportunity to take a step back and to think about the rule itself, not just focusing on did we act timely and appropriately? Were any of our actions responsible for running that 5-year clock, but really take a step back to look at the rule itself. And so in doing that, in stepping back and taking a look at the rule, the question that we asked, staff asked was, so how does this rule further public protection? Why is this rule necessary? If someone passes the bar and otherwise qualifies for admission, how is public protection advanced by limiting you to a 5-year period to get sworn in? And if you don't get sworn in, then you have to take the bar exam again. How is public protection harmed? Is the question we asked ourselves. If you get sworn in after 6 years. In comparison, and I think I'm stepping on Tammy or Amy's presentation here, but in comparison, right? If I passed the bar and got sworn in, I could immediately go inactive. I could be inactive for 10 years, for 20 years. And then I switched to an active license. I don't have a requirement to make up those 10 years or 20 years of MCLE. I'm not required to take the bar exam again. And in our minds, when staff was looking at it, we saw a real comparison between those two items. There's very little difference between the person who meets all the requirements, passes the bar exam, right? Meets minimum competence by passing the bar exam, and fails to get sworn in, having met all of the other admissions requirements, and somebody who also passes the bar exam, meets all the admissions requirement, just gets sworn in. That appears to be the primary difference. And so ultimately, as staff were discussing it, our conclusion was that we don't think Rule 4.17 furthers public protection. There might be a concern that what about the moral character determination? Does that get stale? I think that is a totally appropriate concern and something that could easily be addressed. And I would think that, you know, we could ensure that if it takes longer than 5 years to get sworn in, not only do you have to have a new moral character assessment, but we should also reconfirm before you get sworn in that you are in fact in compliance with any court order for child or family support, as we would when we put you on the motion initially when you're ready to be sworn in. And we did try and trace back the rationale for the origins of this rule. The Office of General Counsel did that legislative history, if you will, for us. We were unable to unearth the information that predated a rule change in, I think it was about 1980. But that rule change focused on extending that period of time from 2 years to 5 years. And there was no explanation in that documentation about the value of having the rule in the first place and how that rule furthers public protection. And we could not identify any documents that predate that went back to the adoption of the rule. So why am I here today? What am I talking about? So what we are here today doing is to hopefully begin a process of getting input from the Committee of Bar Examiners, and ultimately getting a volunteer from the Committee of Bar Examiners to participate with staff in revising the rule. And so we wanted to use this opportunity to share with you our thinking about the rule, and hear your feedback, hear the things that you would want to know before making a decision to change the rule. And so I want to turn it over to Tammy Campbell, because Tammy has pulled together some data and information that she's compiled in anticipation of what some of your questions might be. And so if we can sort of have Tammy walk through that, and then see what other questions you have, what other thoughts you have, and see together sort of what the next steps would be for us to move forward on this.
Thank you, Donna. Good morning, everyone. So as Donna had referenced, she mentioned that the numbers are not really a large quantity that we're dealing with. And to give you some context on those numbers, looking back at the past 3 years, 2019, 2020, and 2021, we have not had a lot to look at, but in 2019, we did have 9 requests for an extension. 2020, we had 14. And in 2021, we had 8 extensions. So as you can see, the volume is not really large. But one of the other sides that we wanted to look at and provide you guys with some information is we looked at some of the other jurisdictions. So on the screen right now, I'm sharing a list that I've compiled with information that talks about some of the different jurisdictions and how they handle it. This is not all of the jurisdictions. That's a lot more in volume to look at, but we did pull the top 10 or 11 jurisdictions to look at. The consensus is anywhere from 90 days to 3 years to 5 years being the most common time frame across these jurisdictions. There are a few that are a little different, a 40-month time frame, which is an odd number. And there's also, like for Nevada, for instance, they talk about having deadlines. If you take the July exam, you have to do it by January 31st of the next year. Or if you take the February exam, you have to do it before August 31st of that year. So that's a little bit of a anomaly from what we were seeing so far. But the standard is either 90 days, 3 years, or the 5-year timeline, which we have already. We looked at whether or not they provide extensions. It was not able to be found in most jurisdictions, as you'll see on this list. If we did find anything that talked about extensions, it was not really specific. There was failure to timely file, could result in resitting for that bar exam again. Same thing with Florida, for example, no specific language found about extension if 90-day deadline passes. Here there was an extension, but we tried to see what kind of background was there. Was there for good cause or, any kind of definition? And unfortunately, we're just, not able to really find a lot of information directly on the websites of these jurisdictions. It's going to be more work trying to see if we can get a hold of them, try to get more detail. But I think this is a good start for everybody to see what are other jurisdictions doing in comparison to how California currently handles it right now. So based on this information, that's all I have to present at this time. And I'm going to go ahead and hand it over to Amy Nunez for her to continue with the conversation.
Thank you, Tammy. Excuse me. Sorry about that. So Dawn highlighted a lot of what I wanted to share, but essentially, we're bringing this to the committee because as you've heard previously, when you compare this rule to what happens and what's required of attorneys that are going from into inactive status, whether it happens right after they get sworn in or whether it happens at any point of their career, the requirement to go into active status is simply to pay for the appropriate fees, the corresponding fees, and to do that. So there are no separate requirements such as taking the bar exam once more, catching up with CLE, so continuing education requirements. And so, essentially what we're doing is when you compare it to our applicants is we're creating a bigger burden for our applicants. That is, if they haven't been sworn in and for whatever reason, they must take the bar exam once more. So again, we bring this to the committee to discuss whether the elimination of a deadline would be appropriate, also, or a part of the consideration. And also, I want to remind everybody that applicants who are fingerprinted with the state bar for licensing purposes also automatically register for the state bar to automatically receive subsequent arrest information. So that is, let's say someone does not get sworn in within 5 years, we would have information about any criminal actions in the event that were to happen. And so I just want to remind everybody, but that is our current process for how we treat how we treat our licensees. And so I see a lot of hands up, so maybe this is a good time to start gathering feedback and thoughts. And again, for a volunteer seeking to pursue this with staff, but let's just open it up then. Larry and Kareem, I know you both have had your hands up for a bit, so maybe we can start with Larry.
Thank you. Yeah, I have a couple of questions and then a comment. So there's not a tremendous concern about knowledge being stale because they took the bar exam 5 years ago, correct?
Well, originally we thought that might be part of some of the consideration there. But again, when you parallel it to what happens with a licensed attorney, it's not a concern in that aspect.
Right. Well, yeah, I mean, it would seem to be inequitable if you worry about their knowledge being stale because they took the exam 5 years ago, as opposed to an attorney who went inactive for 10 years. You know, it definitely doesn't seem fair. Another question I had was when they go in, is there any financial reason somebody would delay getting sworn in?
Some of the cases that have come to us, I think a few, the cost of the moral character application had, they were raising funds to process that application, and that could have delayed this process. Or in some instances, somebody didn't get licensed because they got a job offer in another state or got involved in employment in some other format. So that we imagine is a financial decision, not related to the cost of this process, but it's just a decision that a financial decision made by applicants.
Is inactive status, do they pay dues?
They do. It is significantly less than active status, but nonetheless, I think it may be about $155. And so especially a year, but if you've got somebody who, as Amy said, sort of has moved to another jurisdiction for a job, and they have to be admitted to the bar in that jurisdiction, they're paying those fees. It does seem, right, sort of, since you bring it up, sort of the key difference that I see between somebody who gets sworn in and then goes inactive and a person who passes the bar exam and doesn't get sworn in is that one of them has been paying inactive fees and the other one hasn't. And that's certainly not a reason to distinguish.
Yeah, and it's only $150 a year. How much is it for active status?
It's currently $515.
I see.
There are a variety of deductions that can come off that. So somewhere between roughly $460 and $515.
Okay. Yeah, the only comment I would have is, I think it's a good idea. We've gotten these appeals, and they always seemed really arbitrary to me, especially because some of these people had real hard luck stories. But I think the idea of refreshing the moral character piece is probably a good idea. Because, things can happen to people in a 5-year period that you want to know about. That's my only comment.
Thanks, Larry. Kareem, I think you're next.
Yes, thank you. And let me say thank you for even looking at this rule and kind of taking a different lens. I don't think it's any question about my concerns with this rule and its limitations that it imposes. And a part of it's because a lot of the circumstances that we were provided, in my opinion, were very extraneous and kind of met the rule. But I understood this rule was created with a different intent in mind. And I always was wondering, like, why do we make people relive their trauma to justify their position in the world? And for me personally, we'd hear stories about people with cancer, taking care of their families, dealing with alcoholism, and dealing with issues that are real and that are actually very real in the industry and our culture, and things of the sorts. And so I just hope that moving forward, we're a little bit more empathetic to people like that. We've gotten a lot of training on this committee about how we address those issues and how we review it. And so I'm not in opposition to any moral character requirements or any payments of fees or fines. I think the more we impose fines, the more barriers we create. But I understand there is a purpose for it in some circumstances. And so I'm not against all that. I'm just hoping that moving forward, we just understand we could lead with empathy and think of people in mind first. And so kudos to the team for approaching this, and I'm looking forward to see the progress that we make.
Thanks, Kareem. Robbie?
Thanks, Amy. I agree. A thoughtful review of this. Tammy, I wanted to ask for those ones, because the 2019, 2020, 2021, I've been on the CBE that whole time. Were any of those 5 years reversed either by the committee or by staff? Were any extensions made in those? It sounds like about 40 altogether over 3 years.
Out of all of them, 3 were approved by CBE. Other than that, all others were upheld with a denial based on the circumstances.
Yeah, I agree that it's worth another look. And Amy, I'd like to volunteer to be the committee liaison as we work through it. I think it's interesting that we're taking another look at it. So I'll throw my name in the hat to work with you and staff on that.
Perfect. Thank you, Robbie. All right, Paul?
Yeah, you implied that we would have their criminal histories but I wanted to ask, at what point do we get fingerprints from people who are taking the bar exam?
It's a requirement within the moral character application.
Okay, so somebody who simply passes the bar exam and doesn't bother to go on and complete their moral character process would not be in that situation then.
They would not, but they also wouldn't be on the path to licensure, because moral character is part of that requirement.
Yeah. Okay. Yeah, I guess I've always struggled to reconcile the times where we have granted an extension versus those where we have not. So a clear rule. I think the good cause aspect of it needs to come out, and if we still have a rule, maybe it sets a longer time limit, but I think there should be some, and we don't. It should be just a clear rule with no opportunities to try to gain additional time by tugging at our heartstrings. That's just an opportunity for arbitrary decisions that again would be hard to explain.
So Paul, I just want to respond with a couple of things. So, changing this rule it does not automatically change the moral character rule, which somebody's moral character determination, a positive determination, is good for 3 years. And so that's one thing to keep in mind, that we would, maintain that rule in place. But one of the ideas that also has been thrown around, public protection was of concern, is potentially creating a process of decertifying somebody. So somebody could become decertified, and if they wanted to be considered, then we would recertify them and conduct the entire review once more, meaning they would have to maintain their moral character. We would also, part of our check is also looking at whether somebody has outstanding child support arrears. That is a family code that's part of the licensing requirements, as well as any outstanding fees, any administrative holds on their application altogether. So the idea of decertifying could be potentially a process for this, to ensure that all licensing requirements. Let's say somebody takes 10 years or 15 years to get sworn in. This decertification process would allow us to recertify all licensing requirements at some point. It's just an idea. It's not it's a suggestion to address some of the concerns that you've raised and others have raised about licensing requirements during our discussion.
Okay, well, that's all good to talk about and review, especially since we're unable to put our fingers on the precise motivation for the rule in the first place. Let me just suggest, though, when this comes back, the table that you showed on the screen would have been more helpful to have that available to us ahead of the meeting so we could properly digest it if we thought that was important to look at.
All right, thanks, Paul. David? You.
I concur with my colleagues, and of course I concur to allow Robert Brady to be the volunteer, or Brody. But one of the other things I think that we should perhaps consider on this group is the possibility of retroactivity. In other words, some of the folks within the past 3, 4, 5 years that we have denied entrance to perhaps review their files if they haven't passed the bar as of yet. Thank you.
Thanks, Stephen.
Glad you mentioned that, David. That's something that staff were actually thinking about as well. We'd need to explore sort of how far back that retroactivity would go, what makes the most sense, and that's something that we would look forward to working with Robbie on sort of putting together a proposal about.
Thank you. If you need another voice, I'd be more than happy to work with you folks.
Thank you, David. Oh, Dr. Cal.
Yes, I have a quick question. Tammy, the numbers that you mentioned, the 40 cases that you mentioned, and only 3 were positive and the rest were denied based on procedural basis. Out of those that were denied based on procedural basis, I was just curious, how many actually subsequently moved forward and took the bar exam again to proceed with becoming actively licensed?
Fortunately, I do not have that information. That wasn't part of this exercise that I put together. So I would have to go in and go back and research every single one of those applicants to see if they've actually retaken the bar exam yet or not.
I mean, the reason I'm just asking is, the question, the premise of the question is really finding out what was the intention of this 5-year rule. And so I'm just curious to know, first, for the small number that you mentioned, is how strongly they felt that they needed to become licensed to retake the bar exam. So that's just a question I have.
Yeah, definitely get that information.
Okay. All right, so with that, I will turn it back to you, Alex. I don't think there are any more discussion items, thoughts, suggestions, or ideas.
Yeah, I'll turn it back over to Mr. Asiri.
Thank you for that. And also just thank you for everybody's participate. And this will be exciting to see what Mr. Brody comes up with, along with the staff. Moving on, the next agenda item is the approval of report on 2021 and 2022 operations and management goals. You can see the attachment online, unless if we want to pull that up on the screen. So Ms. Campbell, do you want to pull that up on the screen, or should we?
I can, but
I've reviewed that. Probably most CBE members have too. I will move to approve those goals.
Thank you, Mr. Brody. Do we have a second for the approval?
This is Michael. I'll second that.
Thank you, Dr. Cal. With that, I guess we can take a roll call vote.
Dr. Bolton?
Yes.
Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan?
Yes.
Kareem Gangora?
Yes.
Michael Asiri?
Yes.
Larry Kaplan?
Yes.
Paul Kramer?
Yes.
Vince Reyes?
Yes.
Judge Torrealba?
Yes.
David Torres?
Yes.
Don Wilcoxon?
Yes.
Thank you.
Thank you all. That concludes the open session for operations and management. I'll give that to the chair.
Thank you, Mr. Aseri. Looking at the clock, let's take a 10-minute break and return at 10:40 a.m. and we'll continue in the open session, starting with educational standards. Thank you, everyone. I see everyone, I believe, is starting to come into the room. Just give it another few seconds and then I'll ask Mr. Angeles to take roll call.
Alex Lawrence, I'm sorry, I'm going to take roll call.
Okay, I see we have a couple new members, or at least one new
okay.
member come
got
into
all
the meeting. So Mr. Angeles, would you mind taking roll call again?
Yes, sorry about that. Alex Lawrence,
I believe you're muted.
No, his microphone was working.
Yeah, we can hear him, Alex.
Yes, I can hear you now. Sorry.
okay. Dr. Bolton,
Here.
Robert Brody, Dr. Kao,
Here.
Alex Chan,
Present.
Kareem Gangora,
Present.
Michael Asari,
Present.
Larry Kaplan,
Here.
Paul Kramer,
Here.
Vince Reyes,
Here.
Judge Torrealba,
Present.
David Torres,
Here.
Don Wilcoxon,
Here.
and Robert Brody. Oh, I see you. You're on mute.
Here.
Okay, thank you, sir.
Thank you. So the next item on our list is Educational Standards Subcommittee. I'm going to turn it over to the chair, Mr. Kramer, and Ms. Leonard.
Okay, thank you. First item is 0400. It's action to place on probation or terminate registration as a non-accredited law school for San Francisco International University College of Law. This registered unaccredited correspondence school has not responded to any of our notices or staff communication. It appears to have closed up shop. In December and on every agenda since then, this committee has been going through the successive enforcement steps necessary to enforce compliance with our rules and regulations to no avail. Today, we come to the final step, which is consideration whether to impose probation or termination of its registration. Again, we've heard nothing from the school in response to our communications. Is there any recent news to the contrary, Natalie?
No, there's not.
Okay, so staff's recommendation is termination. Do we have any questions or comments? If so, can somebody, if not, somebody put up the.
I have a, Paul, I have a question.
Okay, go ahead.
Maybe I didn't read it close enough. I didn't understand what happened to the students.
Let
I'd be
Natalie.
Sure, I'd be happy to address that. So Vince, this school was registered in 2017. It didn't start accepting students until somewhat later, and it really had just a handful of students. When the school was last contacted for their spring semester, they really just had one student who was in the process of making an alternate plan. So the students have been kept in mind. And there are no current students at this time. The item does contemplate that we will still do an outreach to past students to make sure that they understand their rights with respect to records, but there were not current students. Essentially, the school received the final inspection report and did not challenge the findings and elected to stop responding.
Great, thank you.
You're welcome.
Okay, so can somebody, there we go, the proposed motion is on the screen.
This is Robbie. I just think that's horrible that they did not even respond. Is that right, Natalie? One way or the other? That's really thumbing their nose at the state bar and the protection that we provide to students and prospective students. So I'm going to move to adopt the motion. Paul, do I need to read it out loud?
I think we've decided no. We haven't been
Okay,
doing that.
well, I'm going to move to support the motion with respect to San Francisco International University College of Law.
This is Vince. I'll second the motion.
Okay, roll call vote then.
Dr. Bolton, Yes. Robert Brody,
Yes.
Dr. Kao,
Yes.
Alex Chan,
Yes.
Kareem Gangora,
Yes.
Michael Iseri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Vince Reyes,
Yes.
Judge Torrealba,
Yes.
David Torres,
Yes.
Don Wilcoxon.
Yes.
The motion passes. Thank you.
Okay, the next item is 0401, and that's action on major change of headquarters for American International School of Law. American International is an unaccredited correspondence law school located in Irvine. As of September 15 of last year, it enrolled 87 students in its JD program. The request is to move from one office building to another within the city of Irvine. The new space is actually larger than the prior location. Although students are not required to visit the facility at all, if they were to do so, that's also better able to accommodate student visits. Staff recommends approval of this change. Any questions?
So moved.
Second, this is Robbie.
Roll call? You're muted.
I apologize. Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Kao,
Yes.
Alex Chan,
Yes.
Kareem Gangora,
Yes.
Michael Iseri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Vince Reyes,
Yes.
Judge Torrealba,
Yes.
David Torres,
Yes.
Don Wilcoxon.
Yes.
The motion passes. Thank you.
Thank you. The next item is
Mr. Kramer, I'm sorry to ask, are you going to, with the item agendas, are you going to see if there's any school reps who would like to make a comment at the time of the agenda items being presented, or wait till you're done through all of them?
No, that thanks for reminding me. Did we have any, I'm working on a much smaller screen than normal here. So if somebody else can be looking for raised hands, and we'll ask any representatives of the school that we're discussing to raise their hand if they want to make a comment. And then we'll look for those.
I can help you with that.
Thank you, Amy. And for the first two items, I actually was watching the attendee list. We did not have any representatives present from SFIU or from American International.
Great, thank you.
All right, so the next item is 402. And that's a similar major change of a headquarters location for the John F. Kennedy School of Law at Northcentral University. They're requesting approval to move their headquarters from Loyola to the city of I guess Loyola is in the city of San Diego, but anyway, to another location in the city of San Diego. Both locations are owned by the National University System, which is consolidating operations between their two locations in the San Diego area. It is an accredited school, and staff recommends approval of this change of headquarters.
This is Robbie. I'll move to approve that with respect to that school.
This is Vince. I'll second the motion.
Go ahead, Ezra.
Thank you. Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Kao,
Yes.
Alex Chan,
Yes.
Kareem Gangora,
Yes.
Michael Iseri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Vince Reyes,
Yes.
Judge Torrealba,
Yes.
David Torres,
Yes.
Don Wilcoxon.
Yes.
The motion passes. Thank you.
Thank you. Next is 0403. It and the following item relate to the Santa Barbara and Ventura Colleges of Law. They're an accredited school with 2 fixed facility campuses in Santa Barbara and Ventura. And they also offer a hybrid JD program with online classes and occasional weekend residencies. And that program draws students from a wide range of locations beyond Santa Barbara and Ventura. They're asking approval of a change of their name to, is it the Colleges of Law, Natalie, or Colleges of Law?
The Colleges of Law.
Okay, so the is capitalized. And that's a name that they've been using informally along with their official name. So now they want to change the official name to the Colleges of Law, which they've been using informally. Their thought is, since they no longer just provide educational services in the Santa Barbara and Ventura area, that this name change will better reflect the wider service area that they now have. Staff recommends approval of this name change.
This is Robbie. You know, Paul, when I think about public protection, which is what I feel like I do on the Committee of Bar Examiners, I'm so, bewildered by the so many, Facebook posts I see about schools with hybrid programs and non-bar exam direction programs. And I don't like that name. I feel like it's, it's just like law school. Like, what does that even mean? What do you like it? Just be, and you've been so thoughtful since you've been on this committee, and I really respect your judgment. But what is it you like about something that's so generic, as if it's the only college of law that there is? It just seems like there's a potential to deceive or mislead, or what is it that you if they want to call themselves that informally, there's nothing we can do about that. But I just feel like a fixed name, a name that's been in use, is more appropriate. But Paul, you talk me out of it, and I'll move to support you.
Well, it's staff recommendation. I agree it is on the generic side of the scale. And I mean, another, I don't want to seem like I'm picking on them, but there's a school called the California School of Law or something like that. That's pretty generic too, and all encompassing, and who would go anywhere else? You might ask. But I'm going to leave it to Nat. Do we have the dean with us, Natalie? She should be selling her proposal rather than me, but in her absence, maybe it's left to you to explain it.
I don't believe the dean is here today. I'll continue to watch the list in case a representative from the school is here. I think part of the issue is this is a regulatory body, but also not a business partner of the law schools. And so we do see some situations where we might have, for example, California School of Law, the California Law School, California Southern University, Lincoln Law of Sacramento, Lincoln Law of San Jose. There are some names that are similar. But this is sort of a market choice of the school, as long as it is correct and not misleading. And this school has been pretty clearly using this for a while. And they've taken a lot of steps already, and they're ready to take more steps to be really clear in their communication that they've got 2 campuses in a hybrid program. So that's why staff did not feel concerned about public protection in this case. In addition, for the accredited rules in the new rule set, the the standard for a name change has been adjusted. Previously, it was approval by the committee, and it was changed to notice for exactly that reason, because the committee is not a market actor. But the school decided to take the very conservative position of continuing to file this. And so I think that that also shows the respect for the authority of this committee, and to be transparent.
Okay, thank you. And I should say, while I'm heaping praise around, during the time on my time on the committee of bar examiners, and I think some of you long timers will agree, Natalie is so on top of these things, and I'm so respectful of the amount of time you put into these. I don't like it, but now that we've talked about it, and Natalie, is this school largely a remote campus?
No, they actually have a very vibrant on-campus presence in both of those two facilities, and then also the hybrid. So they really do put time behind all three formats.
I see that Dean Gardina is now on the attendees list. So would you like to hear from her, Robbie?
Yeah, yeah, Dean, have you been listening to the discussion and I guess, my concern that the name change is generic and maybe implies more than it should in terms of a law school choice?
Yeah, thank you for allowing me to talk. I was using my phone, so I think Natalie probably didn't recognize my phone number. But I've now joined the webinar so that I can be seen. So yes, we've been using colleges of law informally for, well, if you go back through our naming history, it's actually been a colloquial name we've used for decades. What we've done is we now have reversed. We have colleges of law Santa Barbara, colleges of law Ventura, colleges of law online or hybrid. And so it allows us to stay rooted in our community, but also recognize the expansive nature of the school. So it's not losing its location connector, but it's just doing business as colleges of law.
Okay, thank you, Dean. I appreciate you stepping up and giving some more enlightenment. Okay, all right, I'm sold.
Question. Dean Gardina. So I'm looking at your letter, and is the school seeking to use the colleges of law exclusively, meaning no one else can use the phrase the colleges of the law?
The colleges of law is doing business as.
Okay, so I understand that. So are you saying no other schools in California can use that namesake, the colleges of the law? I'm just reading your letter. Maybe I'm reading it a little too much. It says and you italicized it and underlined it, exclusive use of the College of the Law.
We have not yet sought anything like that, and I'd have to speak to the Office of General Counsel to see whether that's the intent.
Okay, because if that is the intent, I think that sort of goes into the factor into the committee's decision. I mean, we can't really say that, or I don't think we have the authority to give you the exclusive naming rights to the use of the College of the Law. If this is what you're seeking, I don't think this is the proper venue to do that. But also one concern I also have is because you have two separate entities, the College of the Law in Santa Barbara and the College of the Law in Ventura, I would assume there are two separate corporate entities, correct? They're not the same entity.
No, it's one corporate entity.
Oh, one corporate entity, just two locations. Okay.
It's just a naming convention. So like University of California, Los Angeles, University of California, Santa Barbara.
Alex, might I propose a thought regarding the exclusive use element? Taken in context within that paragraph, I believe that what it's talking about is that previously, including today at this current time, the school uses both names. They use Santa Barbara and Ventura Colleges of Law, and they also use the Colleges of Law, something like a subheading. And I think what the letter is denoting is that going forward, if this change is approved by the committee, they would stop using the Santa Barbara and Ventura Colleges of Law. They would use only that subhead, which would now become the main title. Does that reflect the intent of the school, Dean Gardina?
Thank you, Natalie. You are doing a much better job at this than I am. Yes,
I'm merely reading your team's clear writing.
thank you.
Any other questions for the dean or staff?
Well, Brody, if it's okay, then I'm going to go ahead and move to adopt the motion with respect to the name change.
That's fine, Chan.
What's next? W Hotel Philadelphia School of Law. Whew. Okay, any second?
I'll second. This is Kareem.
Roll call vote, please.
Thank you. Thank you, Mr. Gongora.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Kao,
Yes.
Alex Chan,
Yes.
Kareem Gongora,
Yes.
Michael Iseri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Vince Reyes,
Yes.
Judge Torrealba,
Yes.
David Torres,
Yes.
Don Wilcoxon.
Yes.
The motion passes. Thank you.
Okay, and leave Dean Gardina active because the next item 0404 also relates to her school. It's action on a major change, our acquiescence to an amended non-JD program for the Santa Barbara and Ventura Colleges of Law, soon to be renamed. And it relates to their non-JD master's degree program. They want to transition it from a Master of Science in Law to a Master of Art in Laws, and they're moving the program to a fully online format. This is a situation where we don't delve into the details of the program, except to determine whether or not it would have an adverse effect on the JD program, which is the subject of our regulatory authority. In this case, staff recommends that it be approved because they've demonstrated that their ability to carry out the program will not detract from its JD program. And they've also demonstrated the capacity to effectively deliver educational content online, as demonstrated in their hybrid JD program. So again, the recommendation is approval. Any questions? Dean, do you have any comments?
No, but I'm here to answer any questions people may have about the program and our capacity to continue with it.
And Jackie, this is Robbie, and I do appreciate you staying on. And honestly, this has been something I've really been thinking about lately. Can you, in just a few words, describe, this is a program that is not a path to be eligible to sit for the bar exam. Is that right?
That's correct.
But you offer that through your law school.
Correct. Just like many schools have a master's in legal studies or something else. So when you look at our mission, it's really training lawyers and other legal professionals. And if you look at the legal industry right now, the business of law is growing and the practice of law is actually shrinking. What this degree does is actually allow for people to get the skills in the business, entrepreneurship, law and technology, knowledge and skills that they need to really do that support role that is around the business of law, allowing the JD graduates to get their license through what other pathway California adopts and do the practice of law. So it's also giving our JD students an opportunity to get that same knowledge and skills so that their pathways into the legal industry are broader, because there's a lot of JD Advantage jobs right now that are really about that business entrepreneurship and tech side of the legal industry. And so this degree is going to widen paths for our JD graduates as well.
And Jack, what jobs are those? What non-lawyer jobs are you referring to? Because I guess I'm too much of a boomer here. I don't know. What are they? HR or?
No, so it's a great question. And I don't know if I provided it to the committee, but I did to our WASC when we went through our WASC process, National Association of Legal Professionals actually has a really great set of data on JD Advantage jobs. Everything from legal operations and legal analysts to data security and privacy issues to certainly HR would fit in there as well. And so there's a host of jobs that do not require a license to practice law, but are intimately connected with the law and the legal profession.
And are the classes, do they overlap? Do your non-JD track students take some of the same classes as your JD track students in the law school?
So the programs are distinct, but what we are doing is making some of the courses available as electives to our JD students. So if someone wanted to get a concentration as a JD student in legal technology or the law of technology, then they would have the ability to do that, but it would be a concentration. So it overlaps as electives only.
And what is it that you get? Do you get a degree? Is it a degree program?
Yes, it's been approved as a Master of Arts in Law by WASC.
And what's the length? If you went full time, what's the length of time to complete that program?
It's currently not set up. I mean, our school primarily serves working adults. So right now it's set up as about an 18-month program, a little bit longer, 20 months by the time you complete that final capstone. But we are working it out so that if someone is performing well and not working full-time, they would be able to complete it more quickly, but probably just in that 12 to 18-month frame.
And just by comparison, what's the time frame for a student that wants to do the JD program to sit for the bar exam?
So we've got both a 32 and 40-month track on the hybrid side and 3.5 years, so about 36 months or a little bit longer for the campus programs.
So, CBE members, I don't mean to belabor this, but I'm troubled by the idea of these programs under the banner of a law school. And Alex Lawrence, I just got an ad for a very similar program to what Jackie described, offered by UCLA School of Law. So I really am a boomer here when it comes to this, but my concern is, are students potentially being, deceived? Here's a shorter program, no baby bar. It's only 18 months. It's this, and you're going to have all the skills you need, except, you cannot sit for the bar exam after you complete this program. I guess, Jackie, that is my concern with schools like yours that are reaching out to, all segments of you're reaching out to many parts of the population that I wish would sit for the bar.
Well, and I certainly understand that, but we are required per CBE rule to actually state quite clearly in everything related to the master's program that it is not something that allows you to be eligible to sit for the bar. And I think one of the things that I want to emphasize is that there are a lot of ways to participate in the legal industry now that do not involve a license to practice law. And I think consistent with our mission, we are educating lawyers and legal professionals. And to the extent that we can bring legal professionals into the values and ethics of our profession, I welcome that opportunity.
Robbie, as a possibility, one thing we could think about for a future meeting is to have a presentation on these types of non-JD programs in ABA environment, CBE environment, et cetera, so that we could have a full discussion about it. It sounds like something you're thinking about very carefully.
Well, I get so many of these that once you get one ad, then the metrics know that you're interested and you get dozens of them. I just saw that one from UCLA. Made me think of you, Alex, yesterday. But yes, but Natalie, I take it, and I have a lot of respect for Jackie too, who I worked with on CAPA. Natalie, you support these kinds of programs under the umbrella of the School of Law, which is where we come in?
Well, in this case, and I might point you to a PowerPoint that I can share about this program. Two things stood out to me about this proposal with respect to the CBE's regulatory authority. The first one is the school not only showed that it won't detract from the JD program, they also showed an expansion and hiring plan so that if the program should be successful, they have the framework in order to allow continued strong operations. And this curriculum is extremely different from a JD curriculum. So taking this curriculum in concert with the disclosures that they must sign, I think it would be very clear to any student who's taking this program that it's not designed to prepare them for the bar exam. It has things like e-lawyering, data security, data breach, privacy. It has those things that are the issues of the day in the business of law. That might be available as electives and are available at the colleges of law as electives, but they're packaged in such a different way that it doesn't appear to be in any way a law degree. But yet it has very important skills that I can imagine the market would want.
Yeah. I have a comment. I'm probably older than you, Robbie, but I'm still a boomer. So I've had the opportunity in the past several years to work with some tech startups in an advisory consultant type position. And there seems to be, just supporting what the dean was saying, there's a lot of different types of knowledge that those techs needed, but usually had to hire a lawyer to do so. So things like intellectual property rights, copyright, security, things like that. And oftentimes they had to bring in an attorney and pay for them, or an attorney was already part of that startup. So it seems to me that there's different, angles where law knowledge would be valuable, but not necessarily having to have an attorney who's passed the bar and is practicing be part of that industry. So just in my own experience, there would seem to be some value. I'm not so clear on the curriculums and where they, depart from each other, but I think in general, I would support the dean's idea around how this should go forward.
Yes, me too. And Mr. Chair, Alex, if I would welcome a discussion at the CBE meeting on these variety of programs under the banner of law schools. But for now, and I, again, thank you, Judge Dean Gardine. I do appreciate
I'll take Judge. That's good.
your thoughtfulness. I'll move then to support the motion.
I see another hand up, Mr. Torres.
Oh, I'm sorry. Oh, well then.
But took it down, but go ahead.
I did. I want to agree. I don't agree with Mr. Brody. I do agree with Dean Gardina. And I personally believe that if somebody were to be deceived by reviewing their brochures, that perhaps they shouldn't be a lawyer, because I think that they're quite clear on delineating what is the law and what are these other programs. But I think that these are new areas that our law schools should get into, and I fully support it.
Are you seconding? Are you seconding me?
Second, I second.
Okay, well, that was faint praise from my colleague, but I'll take it.
Roll call then?
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cao,
Yes.
Alex Chan, Kareem Gangora,
Yes.
Michael Aseri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Vince Reyes,
Yes.
Judge Torrealba,
Yes.
David Torres,
Yes.
Don Wilcoxon.
Yes.
The motion passes. Okay, thank you. The next item is 0405. It's an action on a major change. to create a Monterey College of Law Empire branch campus and changes to the Empire College School of Law, in fact, that it would be closing. There is a lot to unpack here. First, I think we need to identify the players. MCL-ECL, that's the Empire College of Law. It would be a proposed branch campus of the existing Monterey College of Law, whose main campus is in Seaside in Monterey County. MCL, I'm going to be calling them here quite often, has existing branch campuses as well in San Luis Obispo. It's called the San Luis Obispo College of Law, and Bakersfield, called the Kern County College of Law. ECSOL is the acronym Natalie uses in her staff report. That's the Empire College School of Law. The difference between the two names is the addition of the word school in the middle. It's has operated in Santa Rosa since 1981. In 2021, this committee approved that school's request to convert from a for-profit to a nonprofit status. That change, however, was not completed, and the effort will be abandoned if today's proposal is approved. MCL status is as a non-profit 501c3 corporation, just for information. Both schools are also California accredited. Then there is an accrediting agency, ACICS, A-C-I-C-S. That's the Accrediting Council for Independent Colleges, which is authorized to accredit school programs up to the master's degree level, but not to the Juris Doctor degree level. ACICS has accredited the Empire College School of Law's Master of Legal Studies program. That program consists of the first 2 years of the JD curriculum taught together simultaneously, actually. And a law student who completes years 1 and 2 of the Empire College School of Law program earns an excuse me, I'm getting tongue-tied today, an MLS degree. And then after completing years 3 and 4, they would earn a JD degree. By virtue of the accreditation by Access, students in the MLS program, who are again simultaneously taking taking the same classes for JD credit, can qualify for federal student loans for years 1 and 2 of their legal studies. Then there's the final party, the U.S. Department of Education. They administer the federal student loan program, which we generally refer to as Title IV. In June of last year, the Department of Education ceased recognizing Access accreditations as qualifying schools to participate in Title IV. Access has appealed that determination the month following in July of last year, and it is unclear when the appeal will be heard or decided. If the appeal ultimately fails, Empire College School of Law's ability to obtain Title IV loans for its MLS students, MLS/JD students, will likely end in the next year or two. But again, we just don't know the timing. Monterey College of Law is...
Paul, if I might, I apologize to interrupt. I see that Dean Pertil has his hand up because you're talking about schools one at a time. I don't know if you prefer to get through the entire initial presentation or to recognize Dean Pertil at this time.
He might as well wait until he hears the full presentation and he can respond to all of it.
Okay, thank you for that clarification.
So Monterey College of Law is currently seeking accreditation by the Western Association of Schools and Colleges, which we commonly refer to as WASC, and in future years may be able to participate in Title IV, the Title IV loan program, though at present it is not eligible to do so. So that brings us to the proposal before us today. It is different than the proposal that was on the agenda at our last meeting in March, but was withdrawn by the schools. The motivating desire is to transition Empire College School of Law, the existing school in Santa Rosa, from an independent school to be a branch of Monterey College of Law. The tricky part is structuring the transaction and the transition so as to maintain access to Title IV loans and provide an opportunity for existing Empire College School of Law students to earn their degrees. Staff identified some issues with access accreditation and US DOE rules that caused them to recommend denial of the original proposal, which was filed in November. And again, that was scheduled on our March meeting, but it was withdrawn at the school's request. Since then, the schools have modified their proposal, and after discussions back and forth with the staff, have come to the proposal before us today, which staff recommends we approve. The proposal is that Empire College School of Law will admit one more class this fall, the fall of 2022, consisting of first-year students and perhaps some transfers in the upper division class cohorts. But at the end of these new admissions in the fall of 2022, no more students will be admitted after that. Empire College School of Law will teach out those new and its existing students through 2026, which is the normal four-year progression, the end of the normal four-year progression. And they will do so with their own resources for years 1 and 2, though they may contract with Monterey College of Law for some teaching resources for years 3 and 4. Monterey College of Law will purchase many of Empire College School of Law's assets and intellectual property. During the teach out period, both will share the Santa Rosa campus, which will then be owned by Monterey College of Law. And portions necessary for Empire College School of Law to conduct its teach out will be leased back to them by Monterey College of Law. Monterey College of Law will open up its branch in July of this year, but it will not teach its first branch classes until spring of 2023, those being pre-first year classes, kind of introductory classes. Staff believes it is likely, given Monterey College of Law's track record in opening 2 previous branches, that it will be able to compliantly open a Santa Rosa branch campus. Again, staff is recommending approval. There is one issue on the table, though. Monterey College of Law insists that it is necessary for us to add a component to our approval, which is a waiver of a 128-day deadline in order for them to open their Santa Rosa branch in July. Staff in their analysis found no such need for any kind of waiver. We can grant the waiver, of course, if we find good cause for it, but I, for one, need to hear more about the justification for the waiver because either I don't understand it or it appears not to be necessary based on what I've read so far.
I would agree with Paul. I'm sorry, go ahead, Paul.
Okay, yeah, I'm just scrolling my outline here. It's this is the complicated matter of the day. I nominated for that designation. So I guess that is. Let's see. There's one more issue, and it kind of derives. Robbie was hitting on it early on the earlier item. As I mentioned, the names of the 2 schools are identical except for the addition of one word. One is Empire College of Law. The other is Empire College School of Law. Given that the 2 are going to coexist in the same building for approximately 4 years, maybe less, and use it's going to be difficult for students to perhaps keep the two straight in their minds. But the schools have committed to carefully explaining that to its to their students so that there is no confusion. But I wonder if we should not be able to look at those notices and make sure, in exercising our role of public protection, students being part of the public, and get a look at those notices, perhaps with the annual report that would be filed in November, so that we can assure ourselves that there is no confusion, or, as I guess Mr. Torres would say, anyone who is confused perhaps doesn't belong there after reading a clear notice. So with that, we're going to open it up to the law deans first. Dean Pertel, and then I believe Dean Winnick is also available. So if they can be, if their mics can be open so they can speak.
Mr. Kramer, we're in the process of promoting Dean Pertil, but before he speaks, can I just clarify regarding the waiver that your concern is not with is it correct to say that your concern is not with the branch opening in July for administrative purposes, but rather whether a waiver is needed to do so? Is that correct? Does that capture your question?
Yeah, my question is basically, what is it that they want to do that not having a waiver would prevent them from doing?
Okay.
That remains unclear to me.
Okay, thank you. We also have Dean Winnick, who has asked to be recognized as well. And they have both been promoted. Because this is a joint proposal, they might decide between them how they would like to apportion their time and address you.
Yeah, go ahead, gentlemen. Who wants to go first?
Oh, good morning, members of the committee. This is Brian Pertil. Excuse me, got a frog in my throat this morning. First, thank you for the opportunity to speak out during the item and the agenda item. I think that's really helpful for us. Yes, there are a lot of moving parts to this, but believe me, we've spent a lot of time and a lot of thought trying to organize this to make sure our students are fully protected with the programs they have, and that this new project accomplishes the goals that we have in place for Empire. Right now, I think back to about 4 years ago when I first sat in front of this committee, barely 10 days into my job as dean, receiving the renewal of our accreditation and some quite laudatory comments that I still appreciate today, that I was lucky to be taking over there a very well-run institution. I also remember being grateful to the folks who did all of that before me and hoping I didn't mess this up. I can assure you this proposal does not do that. It does not mess anything up. And in fact, it enhances our ability to continue with a Sonoma County Law School. We've spent a lot of time and with great input from staff, frankly, and I've appreciated that very much with the opportunity for the give and take and the back and forth that we've done to answer questions. So I just want to make a couple of quick comments. There has been a lot that's gone on in the last 4 years for North Bay here and for Santa Rosa and for Empire. Many of those issues are being addressed, if not all, by this proposal. I don't want to go into all of this nuts and bolts. I'm here to answer questions as is Dean Winnick, but I want to just give you kind of my overview of what this is bringing to Sonoma County. I'm a local boy. I've been an attorney here since 1984. I've raised all my kids here. If I weren't absolutely sure that this was helping our local community, I would never have been in favor of this, and I am highly in favor of this. So what we hope to be doing is we're going to allow the current owners of the school the opportunity to wind down this business as they want to do, at the same time continue to teach all of our students that we have now and that who will be enrolled by the end of fall 2022, their entire program, still within the existing Empire program. Those students and their core classes are not going to overlap with the new branch. The Monterey then will start to open in July administratively and start enrolling students in 2023. Because the Monterey branch will not add any first year students, and I'll call those first year, meaning the torts, contracts, crim law cohort, until fall of 2023. And our last first year cohort is this year, fall 2022. We're not enrolling any new students after that. So they will never fall together in the exact same classes for their core classes. And all of our current students, as I mentioned, will be allowed to be taught out in our current format, in our current framework, with the same program, the same degrees that they've signed up for already. So that's was very important to us too, and that we were able to complete that. That's part of the additional changes we made from the first submittal with the guidance and input from the State Bar staff, which again was great, very helpful. So the new Empire branch is still going to maintain its local flavor. We're going to keep the same administration, the same faculty. But what it will do is enhance several of the things that we've always wanted to bring to the table, and especially since I've been here, things I've identified as wanting to be added to our program. We will be able to add more academic counseling and support services for the students, because Monterey has more of those than we do. We'll have more choices of electives and different faculty members. We'll also get additional financial aid opportunities. As Mr. Kramer mentioned, we're not quite sure what the ACICS situation is, but over time, we assume that this is all going to balance itself out. We're not going to be adding any new students. So to the extent financial aid is available now, it will remain as available as long as the Department of Education allows it. So we had limited financial aid ability as was. Hopefully with the process and Monterey's branch coming in, and if Monterey completes its accreditation process with WASC, then that will open up even further financial abilities. But also being a nonprofit school, there are other financial aid potential loans that are available to students who don't have those now because they don't go to a nonprofit school. So this process really meets a lot of our goals and continues to keep our students, the current students, in their programs without any interruption. So we could go on about this a lot, and I'm here to answer questions. I know that Dean Winnick is here. He can answer better the issue of the waiver. But I can tell you that I couldn't be more optimistic about the way this is all coming about and the future of the Sonoma County Law School. I really appreciate the time that staff has put into this and given us the opportunity to revise that proposal so that it was more in line with what everyone wants to make sure happens. And I appreciate the recommendation from staff that this be approved. So I'm here to answer any questions, as I'm sure is Dean Winnick. Thank you.
Okay, Dean Winnick.
Thank you, Mr. Chair. I'll just add two things to clarify. First of all, it appears from the staff memo that the waiver is not necessary. I would agree with the staff's recommendation that if this is a continuing application that started November 15th, the rules specifically allow what we're requesting, which is to open in July. So I believe staff has addressed that very well, and I'm in support of that. Let me reinforce what Dean Pertil said. There should be no confusion about the name, because the Empire College School of Law students, which will be a fixed cohort as of July or the fall of 2022, will continue their degree and finish their degree and receive their diplomas from Empire College School of Law. That name will no longer be part of the public marketing or awareness, other than those students who are already in the program and just finishing their degree. As was indicated, starting in July, we will begin the new identity of Empire College of Law as a branch of Monterey College of Law. So those two entities really never overlap in the public eye. So I don't see that there's a risk of confusion, but we are certainly happy to provide copies of any of the notices that'll be provided as part of the marketing, enrollment, and admissions process as part of our annual reports. Thank you.
Okay, do any committee members have questions for either the deans or staff? Did we have any other comments from the public? Do we see any?
Well, I have a comment. I just wanted to, several years ago, Dean Winnick purchased or opened a law school here in the Bakersfield area, and it is thriving, and they are working closely with members of the bar as well as local high school students in getting the word out. But not only that, they have an excellent staff, and I'm certain that what he's done here in Kern County, he will likewise do with Empire. I think that what Dean Winnick's organization does is provide financial stability for this organization to thrive, provides excellent staff, and I believe that based upon what Natalie stated as well as the deans, that they have been working closely with the bar, and I would move to approve. And just to clarify, we don't need a waiver on the 120, correct?
To clarify what again?
We don't need to worry about the waiver, I think is what Mr. Torre said, because Dean Winnick indicated he was in agreement that that was not necessary for us today.
Okay, Dean Pertel, your hand is still raised. Is that just because you didn't take it down? Or did you?
Partly, but I would like to just say that is what Judge Torrialba just mentioned is one of the great benefits that we see too, is that we were trying to get transitioned into a nonprofit. Some of the Department of Education function held that up, and that's in limbo as well. And by being under the umbrella of Monterey, they have been operating their nonprofit campuses so successfully for so many years that it's going to take so much other time and expense and education off of our shoulders to try to create that on our own. So I just wanted to add that is another extreme benefit that we see in this process. Thank you.
Okay, thank you. I don't see any other raised hands.
I'm going to second Mr. Torres's motion to adopt.
Okay, and is there a second? Okay, you seconded. Let's take the roll then.
Dr. Bolton? Robert Brody?
Yes.
Dr. Cao?
Yes.
Alex Chan? Kareem Gangora?
Yes.
Michael Asari?
Yes.
Larry Kaplan?
Yes.
Paul Kramer?
Yes.
Vince Reyes?
Yes.
Judge Torrialba? David Torres?
Yes.
Don Wilcoxon?
Yes.
Thank you. The motion passes.
Thank you. And thank you to the deans for offering to share their notices with us. That'll give us the assurances that we are concerned about. Okay, and I guess I'll say this is an example where when staff works with the applicants, they can make a proposal better from everybody's point of view. So thank you, Natalie, and the rest of the staff for that.
You're very welcome. And we look forward to what Monterey College of Law will bring. They are uniquely versatile in the California market. They've created a branch from scratch. They've taken over a branch. They've pioneered a hybrid format, which is something that is new to Empire College of Law. So it will be exciting to see them bring those skills and that experience to the Santa Rosa area.
All right, the next item is 0406. That is an action on the periodic inspection of the University of San Joaquin College of Law. This is somewhat unique in that the inspection, maybe not unprecedented, but the inspection team consisting of Heather Georgiakis and our own Dr. James Bolton came up with only 2 recommended mandatory actions. You'll see those on page 2 of the staff report. And the law school submitted a letter accepting the recommendations and committing to address them before the start of their summer semester. So there really are no issues to hash over. The recommendation is that we receive and file the report and accept the law school's formal response, continue the accreditation of the school, and set its next inspection for the fall of 2026 unless we determine that an earlier inspection is required. Does anyone have any questions?
I don't have any questions. I actually will move to support the proposed motion, but I will state that this is an excellent school. Living in the Valley and Kareem, you know, I know you talk a lot about the Inland Empire, and this school is an excellent school to take a look at. It's the type of school that's been in existence for quite some time, serving the community. It's my understanding that half of the bench officers in Fresno County are graduates of this law school. So they've been around for quite some time, very well respected, and obviously looking at their bench or the composure of their bench, something is they're doing something right over there. But I do move to approve.
I'll second that.
Take the roll, please.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cao,
Yes.
Alex Chan, Kareem Gangora,
Yes.
Marco Aseri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Vince Reyes,
Yes.
Judge Torrealba, David Torres,
Yes.
Don Wilcoxon.
Yes.
The motion passes. Thank you.
Thank you. Next item is 0407. It's a report on administrative updates for accredited and unaccredited law schools. This is simply a receive and file item. Do you wish to highlight any of the information that's contained therein, Natalie?
I believe the report speaks for itself.
Okay, so with no motion, correct?
Correct.
Okay, then we'll move on to our committee goals, 0408. We won't go through these except to, unless somebody wants to raise a particular item, either that's in there now or suggest an item that should be added. I'll note that goal number 12 at the end is one that we discussed adding at our last meeting, and Natalie has drafted this. It's a study process related to teach outs and closures to determine best practices to preserve student records and minimize disruption to legal education. And I'll note that at the CS BARS meeting on Wednesday, that group gave themselves homework to start brainstorming about things we might be able to do to help preserve records. For me, it was kind of thrown into focus by the first item on our subcommittee agenda today, where the school has just gone radio silent, and we have no idea what's happened to the records. Thankfully, it had a small number of students in its brief time, and so not a lot of people would be affected, but it could become a problem for someone if their school closes on them unexpectedly and they can't get the records to show to another school that they want to transfer to, that they've already successfully taken a bunch of classes. And I'm not sure there's a solution to this problem that will solve every situation, but we're at least thinking about it.
Well, we could include the presentation on some of the master's programs on the hybrid courses or classes.
Yeah, thanks for the reminder. So Natalie, can you put something together to add for our next meeting?
Yes, I'll make that change. And to be clear, I will add the goal for the next meeting rather than specifically the presentation. Is that correct?
Yes.
Yeah, it'll be in the future, I would presume.
Thank you.
Yes, with that addition, because I am really interested in learning more about those. I appreciate that, Paul and Natalie. I'll move to approve the goals then.
I'll second.
Roll call.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cao,
Yes.
Alex Chan, Kareem Gangora,
Yes.
Michael Aseri,
Yes.
Larry Kaplan, Paul Kramer.
Larry, do you vote yes?
Thank you.
Yes, from Paul.
You vote
Vince Reyes?
yes?
Paul is voting yes.
I have Larry Kaplan and Paul Kramer as yes. And Vince Reyes,
Yes.
Judge Torrealba,
Yes.
David Torres,
Yes.
Don Wilcoxon.
Yes.
Thank you. The motion passes. Okay, that's it for Ed Standards. Thanks to Natalie and the rest of the staff for working through these items. Alex?
Great. Thank you, Mr. Kramer. Thank you, Ms. Leonard. The next item on our agenda is moral character. So I will hand it over to the chair, Mr. Reyes.
Thank you, Chair. This is to approve our moral character goals for 21 and 22. In addition to our function of making final determinations for appellants, we have a number of presentations this year. We've already had one, but we'll continue to look at topics that would help us better understand and appreciate what happens in the course of denials or mainly denials. So we sent people to LEP or the State Bar Ethics School, client trust accounting. So we're going to have presentations on those just so that we understand more fully what goes on in those classes. Later in the year, we'll take a look at the new admissions rules and how those would apply to moral character. So that's pretty much our goals. I didn't go through them in all the detail, but we're looking for a motion to approve these goals. Any questions?
This is Robbie. Thank you, Vince. I'll move to approve those goals. Well stated.
Second.
Second by the able Mr. Torres.
Thank you for that. And Dr. Bolton?
Yes.
Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan? Kareem Gangora?
Yes.
Michael Asari?
Yes.
Larry Kaplan?
Yes.
Paul Kramer? Vince Reyes?
Yes.
Judge Torrealba?
Yes.
David Torres?
Yes.
And Don Wilcoxon?
Yes.
Thank you. The motion passes.
Yeah, thank you for the vote. I'll turn it back to our chair.
Thank you, Mr. Reyes. So that concludes the open session. I would like the committee members and State Bar staff to leave the open session and join the closed session. You should have received an email from Ms. Nunez with the subject line closed session, April 22nd, 2022 CBE meeting. So please go to the closed session now. Thank you.